Judgment in the matter of UKI Kingsway Limited versus Westminster City Council.
Lord Carnworth will explain the decision of the court.
Under the Local Government Finance Act 1988, a new building that has not yet been occupied may be made liable to business rates by service on the owner of a completion notice. This appeal concerns the Appellant Council's attempted service of a completion notice for a building owned and under redevelopment by the Respondent UKI. The agents with whom the Council were dealing were informed of the Council's intention to serve the notice, but they declined to provide the owner's address. For reasons which are not clear, the Council did not use one of the alternative methods of service provided by the Act in that situation, but instead delivered a completion notice by hand to the building, addressed to the owner at the address of the building. It was given to a receptionist employed by the company managing the building for the owner, who then scanned and emailed a copy of the notice to UKI by whom it was received. The short issue in this appeal is whether that constituted good service on UKI. There was disagreement on this issue in the courts below, and the Court of Appeal answered it no. But the Supreme Court now unanimously allows the Council's appeal for reasons given in my own judgment. There were really two questions for the Court. First, did it matter that the notice was not delivered directly to UKI, but passed through the hands of a receptionist who was not an agent of UKI nor authorised for that purpose? Secondly, did it matter that it was received in electronic rather than paper form, in the absence of any specific provision for this situation under the Electronic Communications Act of 2000? Dealing with those in turn, as to the means of service, the methods prescribed by the Act are not exclusive. Under ordinary common law principles, the material issue is whether the Council caused the notice to be received by UKI. That issue is one of causation, which does not depend on concepts of control or agency. It was enough that the receptionist had done what would reasonably be expected of a responsible employee in that position. It was the natural consequence of the Council's actions. On the second point, before the enactment of the Electronic Communications Act 2000, the common law had recognised that service by fax of a copy was valid. There is no good reason for distinguishing transmission by fax from transmission by email, as happened in this case. Against that background, Parliament must be taken to have legislated with that in mind. There is nothing in the 2000 Act to deal with this particular situation, but then there is nothing in the Act to displace the ordinary presumption that Parliament does not intend to change the common law. Accordingly, the method of service by electronic means was valid.
Thank you. The court will now adjourn.